and the deck is stacked against you from the moment you see those flashing lights in your rearview mirror. But what if you knew the 5 exact tricks cops pray you never learn? Not myths, not loopholes, but the foundational legal and tactical countermoves used by defense attorneys. In this video, we're going inside the hidden playbook of traffic stops. A former prosecutor and defense attorney breaks down the precise moves that protect your constitutional rights, keep you physically safe, and stop you from voluntarily handing over evidence that can convict you. These aren't theories. These are real, legally backed strategies that expose the startling amount of power you actually retain in that vulnerable moment. Miss even one of these steps, and you could lose thousands of dollars, your driver's license, or even face jail time. By the end, you'll possess the 5 traffic stop secrets that change everything, and you'll understand exactly why law enforcement never wants this knowledge in the hands of ordinary, informed citizens. Trick number 1. The first question you must ask: what specific statute did I violate? The trap. The officer begins with a vague assertion. You were weaving, you have a taillight out, or the classic, do you know why I pulled you over? This vagueness is intentional. It invites you to speculate, confess, or remain in a state of confused compliance. The legal standard for a traffic stop is reasonable articulable suspicion of a specific traffic violation or crime. Weaving is not a statute. Failure to maintain a single lane, Code Section 32-5 and -88, is. The countermove. Before you hand over a single document, in a calm, neutral, and respectful tone, ask, "Officer, from my understanding, could you please tell me the exact statute or ordinance you believe I violated?" Every single day, drivers get pulled over and make costly mistakes. Mistakes police count on. It's a high-stakes game where the rules are never explained. Why this is a game changer. Forces legal footing. You immediately require the officer to articulate a legally valid reason. If they cannot cite or clearly describe a specific law, the detention's legitimacy is in question from the start. Creates a critical record. Their answer is now part of the encounter. If they say broken taillight, but the video shows it's working, your attorney has grounds for a dismissal. If they later claim they smelled alcohol, but initially said speeding, the narrative weakens. Shifts psychological dynamic. You transition from a passive subject to an informed participant. You are not arguing. You are fact-finding, which is your right. This sets a tone of measured, rights-aware interaction. Execution detail. Do not sound accusatory. Phrase it as a request for clarification. If they reply, for a traffic investigation, you can calmly follow up. I understand. I'd like to know the specific traffic law in question so I can be sure to address it correctly. Their evasion or clarity is powerful information for you. Trick number 2. The atomic rule, 0 admissions. Your mouth is an evidence factory. The trap. The officer's questions are designed to harvest self-incriminating evidence. Do you know how fast you were going? Where are you coming from in such a hurry? Have you had anything to drink tonight? Your brain, flooded with adrenaline, seeks to be helpful or defuse tension. This is when you are most dangerous to yourself. The countermove, a polite, unwavering policy of no admissions. You provide your 3 required documents: license, registration, proof of insurance, and then you stop talking. The critical nuances. Do you know why I pulled you over? The only safe answer is, no, sir/ma'am, I do not. Any guess is an admission. To how fast do you think you were going? Do not guess. A safe reply, I don't wish to answer that question. Or, I trust your equipment, officer. To where are you headed/coming from? This is a fishing expedition. A polite, I'm not discussing my day, officer. Here are my documents, is perfectly acceptable. Wise silence is golden. Anything you say is recorded on the officer's body cam or in their memory and becomes prosecution evidence. A casual, I had 1 beer with dinner 2 hours ago, is now probable cause for a DUI investigation, even if you're stone cold sober. You cannot talk your way out of a ticket, but you can absolutely talk yourself into arrest. Trick number 3. Fortify your position. Lock, crack, and control the environment. The trap. You sit passively, window fully down, engine off, doors unlocked. The officer now has unrestricted access to your cabin's sight, sound, and smell. A plain view, observation of anything can escalate the stop. The physical dynamic is one of total exposure. The countermove: as you pull over and before the officer exits their cruiser, lock your doors and roll your window down only 2 to 3 inches, just wide enough to slide documents through. The tactical and legal rationale. Safety first. A locked door prevents a sudden, unexpected opening. It is a basic safety measure. Controls plain view and plain smell. A cracked window significantly limits what an officer can see or smell inside your car, protecting you from a fishing expedition search based on a claimed odor or suspicious item. Sets a professional boundary. It physically demonstrates you are cooperating, you can pass documents, while maintaining a reasonable expectation of privacy for your vehicle's interior. If the officer asks you to open the door or roll the window down further, they must now make a deliberate request, which you can acknowledge and comply with calmly, rather than it being a default condition. Script your actions. You can verbalize this to de-escalate. As they approach, you can say, "I'm rolling the window down to pass you my documents now, officer." This communicates compliance while you establish the boundary. Trick number 4. Master the art of the polite decline. Neutralizing verbal ambushes. The trap. After the initial documents are exchanged, officers use a friendly chat to lull you into a false sense of security. They're trained in conversational elicitation. Questions about your job, your travels, or your evening are not small talk. They're building a totality of circumstances profile to justify extended detention or search. The countermove: you must become a master of the polite, non-engaging decline. Your new default phrase: "Officer, I respect what you're doing, but I do not answer questions. Am I being detained?" Or, "Am I free to go?" Deep dive on why. Inconsistency is king. Any detail you give can be later misremembered or twisted. "He said he was coming from a party and seemed nervous" becomes PC in a report. It ends the fishing trip. This refusal forces the officer to either let you go if they had no real cause, formally detain you, requiring a higher legal standard, clearly state you are not free to leave, which is a critical legal milestone. It is your right. The Fifth Amendment is not an admission of guilt. It is a procedural shield. Use it. Trick number 5. The ultimate litmus test. Ask, "Am I free to leave?" And ask it again. The trap. The stop seems to be wrapping up. The officer has your license back. But instead of ending it, they linger, ask more questions, or call for a K9. They're trying to prolong the detention to develop probable cause for a search. Most drivers assume they must wait indefinitely for permission to leave. This is false. The countermove: at the natural conclusion of the business, getting your license back or receiving a citation, you must ask the defining question: "Officer, just so I'm clear, am I free to leave now?" The power of the double tap. First ask clarifies the status. If they say yes, you say thank you and drive away calmly and safely. The crucial second ask: if they hem, haw, ignore you, or say in a minute, wait 30 seconds and ask again with calm precision. "I asked if I was free to leave. Am I being detained?" Or, "Am I free to go?" Why this is your most powerful tool. This question forces the officer to either release you or officially convert the stop into an investigative detention, which they must be able to justify in court. A prolonged detention without reasonable suspicion is illegal. Your repeated, polite question documents that you sought to understand your status and that they continued to hold you. This is a cornerstone argument for suppressing any evidence found after that point. Your new reality. This knowledge transforms you from a subject into a citizen who understands the framework of the encounter. You're not a legal expert, but you now know the rules of engagement. Your weapon is calm, informed assertion of your rights. These 5 tricks form an integrated defense system. One supports the other. You control the space. Trick 3, you demand legal clarity. Trick 1, you silence the evidence factory. Trick 2, you decline the verbal traps. Trick 4, and you definitively test the limits of the detention. Trick 5. If this breakdown of the hidden playbook empowers you, secure your advantage. Smash that like button It tells the algorithm to share this knowledge. Subscribe with notifications on, because this channel is dedicated to turning legal insight into personal power. Share this video widely. Arm your friends and family. When more people know their rights, everyone is safer. That bell icon is your subscription to protection. Hit it. The next time those lights flash, you won't just be prepared. You'll be in control.